Welcome to The Explainer. Today, we're tackling a question you've probably heard a million times, especially if you watch any courtroom dramas. It sounds like such a simple, straightforward question, right, doesn't it? But what if I told you the answer is one of the most misunderstood concepts in the entire legal system? Seriously. For over a century now, the phrase burden of proof has caused so much confusion that it's tripped up not just regular folks, but experienced lawyers and, yes, even judges. So let's clear up that confusion for good. The first thing you need to understand is that burden of proof isn't just one thing. It's actually two completely separate burdens hiding under one name. First up, we've got the legal burden. The easiest way to think about this one is that it's the main quest. It's the ultimate job, the big one, to persuade the jury or judge. This burden is fixed on one party, and if they fail, well, they risk losing the whole case. And then there's the evidential burden. This is a totally different animal. Its job isn't to prove anything, not at all. Its only purpose is to put just enough evidence on the table to make a judge say, okay, yeah, this is a real issue we actually need to discuss. Seeing them side by side like this really makes it click. See, the legal burden is aimed at the jury. The whole point is persuasion, and the stakes are as high as they get. You win or you lose the case. But the evidential burden, that's for the judge. And the only consequence is whether your issue gets considered or just dismissed right then and there. This video game analogy is just perfect. Meeting your evidential burden is like beating a mini-boss. You have to pass the judge to unlock the next level where your argument can even be heard. But the legal burden? Oh, that's the final boss. That's when you have to persuade the jury to win the entire game. All right, so that's the theory. But what does this actually look like in a real trial? Because let me tell you, mixing these two up isn't just a small technical error, it can completely change the outcome of a case. So let's dive into the famous case of Wilmington v. DPP. Here, a man was accused of murdering his wife. He admitted the tragic event happened, but his story was that it was a pure, devastating accident. This is what the judge told the jury. Now, that sounds pretty logical, doesn't it? I mean, he's the one making the claim about an accident, so he should have to prove it, right? Well, that seemingly common sense instruction was a massive fundamental error. So serious, in fact, that it caused his conviction to be overturned. So here's where the judge went wrong. He got the two burdens completely mixed up. He told the jury that Wilmington had the legal burden to prove his accident story. But in reality, all Wilmington had was an evidential burden. He just needed to introduce enough evidence to make the accident seem plausible. The ultimate legal burden to prove guilt beyond a reasonable doubt, that never ever left the prosecution. And don't think this was some dusty one-off mistake from a long time ago. This exact same confusion has popped up time and time again in modern cases, especially ones involving self-defense or consent, forcing appeal courts to constantly drill home this vital distinction to ensure trials stay fair. So why do we get so hung up on what seems like a technical legal point? Why does it matter so much? Because, it gets right to the very heart of how our justice system is built to handle doubt. The legal burden is way more than just a procedural rule. Its most crucial job is to be the system's official tiebreaker. It answers one simple but profound question. What happens when the jury has heard everything and they're still not sure? What happens when they are left in doubt? Well, think about it. If a jury in a criminal trial is undecided, that means the prosecution, the side that had the legal burden, failed to convince them. So the tie automatically goes to the accused. The verdict is not guilty. Same thing in a civil claim. If the jury's on the fence, the plaintiff, who had the burden, loses. It's the system's default setting for dealing with uncertainty. So the next time you hear someone ask, who has to prove it, you'll know the answer is way more interesting than it looks. It all depends on whether you're just trying to raise an issue or you're trying to win the whole case. It's not about who talks first. It's about who bears the risk of doubt. And understanding that, well, that's not just legal trivia. It's understanding a cornerstone of justice.